Okay. So, and actually, I'll bounce to Mr. Selsky very quickly. Attorneys are not necessarily fact witnesses, but you are allowed to make factual representations that you choose to make. Is Mr. Dew's understanding consistent with your understanding of the facts on the ground at this time?
Yes, Your Honor, and those remain true as of about a half hour ago when I spoke with my client.
Okay, so Mr. Dew, have you and Mr. Selsky or the Department of Labor and Industries and Spiffy's had recent communications about whether or not this case is moot at this point?
No, we have not had those discussions, Your Honor.
Mr. Selsky, my question, again, understanding that attorneys are not witnesses, but you may choose to reveal certain factual representations that may further your client's interests. Does your client at this point choose to represent to the court that it is not going to reopen for dine-in services, at least for the duration of the current restriction on dine-in services that's in effect in this state? In essence, the short version is, what's happening right now with your client in dine-in services, if you're able to tell me?
Your Honor, I do know they do not plan on reopening at this point in time.
Okay. Mr. Selsky, what is the state's position about proceeding with today's hearing? And I will indicate to you what my initial thoughts are regarding that. And I will hear from both parties if you believe that I should head down a different path, understanding, of course, that it can be difficult to tell a judge to his or her face that you think they're wrong, but we want to make sure we get this right. And so what I view here as I look at the standard that governs preliminary injunctions is that number two is that the party has a well-grounded fear of immediate invasion of that right. That, in our earlier case today, was demonstrated by the continuing operations of dine-in services by the dining establishment at issue in that case. It sounds like at this point, we don't necessarily have a record that supports at least that type of fact that might be used to support that element. What my inclination in these circumstances is to deny without prejudice the motion for a preliminary injunction at this case based upon the factual representation that there doesn't appear to be any dispute as to at this point, that Spiffy is currently not providing dine-in services, and that there is not any indicia that they're going to, at least for the duration of the order, continue to offer dine-in services. With that ruling, I would also note that should for some reason, and I have no reason to believe that anything nefarious is afoot here, but if for some reason they were, while the restrictions were still in place, choose to reopen and in a manner that was again offering dine-in services, that on very short notice, we would have this hearing for the preliminary injunction that may be noted up again through our ex parte procedures for a shortened time hearing, because the briefing's already done. All that would need to be done under those circumstances, which again, I'm discussing a contingency here that it sounds like based on Mr. Selsky's most recent information should not come to pass. But if it does come to pass, I'm trying to anticipate these different contingencies. We would have a shortened time hearing for a motion that's already been fully briefed. That would only require an additional factual submission about what is currently happening on the ground. What are your thoughts? I'll turn to Mr. Dew first about heading in that direction with this hearing today.
Thank you, Your Honor. I don't have any objection to that method or that procedure. My understanding is the TRO will remain in place during the pendency. I think that will protect the department's interests. And should things change, we're happy to come in on shortened notice
Again, I'll clarify here, because this is the hearing for the preliminary injunction. The temporary restraining order would expire. There wouldn't be a court order any further ordering this. Doesn't mean that on shortened time there couldn't be another ex parte application for that if it continues to be the case, and that we could then renew these proceedings. But the TRO under court rule can only continue to operate until there is a hearing on a preliminary injunction. At this point on this record, it doesn't look like a preliminary injunction could issue without some additional indication that Spiffy's is temporarily closing only to, quote unquote, game these proceedings, using my expression, to obtain a denial. That doesn't appear to be the case, but if it should prove to be the case, I believe that this would not prejudice the plaintiff in terms of its rights, because we could proceed on a very expedited fashion to pursue another court order and head back in that direction. What do you think about that?
With that clarification, the department is still willing to go along with that proposal.
Okay, thank you. Mr. Selsky, I can guess what you would think about me denying the request for the preliminary injunction without prejudice, but I would like to formally hear what your position is on behalf of your client.
We have no objections to that, Your Honor.
Thank you. And so at this time, based on the conversation and the reasons we just stated on the record, this department has moved for a preliminary injunction. One of the elements that they are required to show to obtain a preliminary injunction is that there is a well-grounded fear for immediate invasion of the right at issue. Specifically in this case, that would be that Spiffy's would continue to offer dine-in dining services. Based on the record that we have at this point, it does not appear that the department could satisfy that burden, and thus the court, for the reasons we just discussed and with the understandings I just discussed, is going to be denying without prejudice the request for the preliminary injunction. I should be clear, though, this does not mean that this case is dismissed. Should this end up in a resolution, or let's just say once the COVID restrictions are lifted, I would imagine the parties might be able to stipulate to a stipulated dismissal of this action, barring further action that requires further court involvement. And if things require further court involvement, we could proceed in that direction in an expedited manner, as is the nature of these proceedings, and because we already have the briefing on a preliminary injunction request. And I specifically noted, I believe that on an ex parte basis, again, a new order would be available under the law, and we could then proceed directly to the preliminary injunction hearing on shortened time, as we were prepared to do today. But we can't, such a request could not be satisfied on this record at this time. And so based on the representation from Mr. Selsky that Spiffy's is not currently offering dine-in services at their restaurant, and that there is no intent to begin offering those services again for at least the duration of the currently existing COVID restrictions, the court is denying without prejudice the request for a preliminary injunction in this case by terms of the temporary restraining order that had previously issued from this court. That is no longer in force in effect and is lifted. But again, if for some reason we head down the contingency where those services are offered again, in quick order, that order can issue again if the requirements as were previously satisfied are satisfied. Do the parties require any clarification at this time? Mr. Dew?
No, thank you, Your Honor.
Mr. Selsky?
No, Your Honor, thank you.
Thank you. And so just so that the record is clear, and Mr. Dew, I know that you're not necessarily the prevailing party on this, but I'm going to ask, because this was your motion, if you could prepare a brief order that simply says that the request for the preliminary injunction is denied without prejudice based on the representation from defendant that they are not currently providing dine-in services and do not intend to begin offering those services again for at least the duration of these restrictions. I'm gonna let you type that up there. That would be appreciated. I think that's the only order that's necessary. We're not dismissing this case yet. I fully hope and anticipate it will be dismissed through agreement of the parties soon, but we're not quite there yet. Do the parties have any other questions or require any further clarification? Mr. Du?
No, thank you, Your Honor.
Mr. Selsky?
No, Your Honor. Thank you.
Thank you, everyone, for your service and for your assistance in this hearing today. That's going to conclude this hearing. The court is in recess. Thank you.
Wow. They drove him out of